After the Founding Fathers had formed the Constitution, outlining the laws as to the way our government was to be run, Thomas Jefferson said, in essence, this proves that plain people, if given the chance, can enact laws and run a government as well as or better than royalty and the blue bloods of Europe. The American people must stop thinking that lawyers are better than they are, and can do a better job than they can before the courts of America. Under the common law and the laws of America, nowhere is it expressly given for anyone to have the power or the right to form a corporation. Corporations are given birth because of ignorance on the part of the American people, and are operating under implied consent and power which they have usurped and otherwise stolen from the people. By right and by law they have no power, authority, or jurisdiction, and must be put out of business by the good citizens of America in their fight for freedom. The United States Constitution guarantees to every state in this union a republican form of government. Any other form of government is forbidden. No public officer or branch of government can be limited to a ruling class of any kind, or the states become aristocracies and not republics. Also, the lawyers have made themselves first-class citizens, where many public offices and branches of government are open to lawyers only. All other people are limited to only 2 branches of government and to only certain offices in those 2 branches of government, making all people who are non-lawyers into second-class subject citizens. When the courts belong to the people, as the United States Constitution requires, Article 4, Section 4, we the people will never rule against themselves. In these unconstitutional foreign tribunals, courts, hoodlum centers, men in black dresses that are unconstitutional robes of nobility, Article 1, Section 9 and 10, dispense a perverted ideology, where the people are terrorized by members of the black robe cult, lawyers and lawyer judges in the courtrooms. The legislative branch of government does not have the constitutional power to issue court orders or any other kind of orders to the people, as a fiction court, or a court corporation for profit and gain, cannot reach parity with a lawful man. Only presidents and governors have the constitutional power to grant pardons, but lawyers and lawyer judges are unconstitutionally granting pardons with immunity from prosecution. Citizens are not permitted to act like people in the courts. The citizen, second class, is told that he does not know how to fill out fancy lawyer forms, that he is not trained in the law, that he does not know court rules and procedures, and so on. This is an unconstitutional lawyer system. Only hearsay substitutes lawyers not under oath have access to the fiction for profit and gain courts, even though only sworn testimony and evidence can be presented in court. Anything else is bill of attainder, not permitted under the United States Constitution, Article 1, Sections 9 and 10. The United States Constitution does not give anyone the right to a lawyer, or the right to counsel, or the right to any other hearsay substitute. The Sixth Amendment is very specific, that the accused only has the right to the assistance of counsel, and this assistance of counsel can be anyone the accused chooses without limitation. Lawyers and lawyer judges created unconstitutional lawyer system pre-trial motions and hearings to have eternal extortionistic litigations, which is barratry, and also is in violation of the United States Constitution, and Article 1, as this places defendants in double jeopardy 100 times over. Defendants only have a right to trial, not trials. When a criminal is freed on a technicality, he is freed because of a fix and a payoff, as a defendant can only be freed if found innocent by a jury, not by any technicality. Whenever a lawyer is involved in a case directly or indirectly, as a litigant or assisting in counsel, all lawyer judges have to disqualify themselves, as there cannot be a constitutional trial, and also there would be a violation of the conflicts of interest laws, along with the violation of separation of powers and checks and balances, because officers of the court are on both sides of the bench. These same lawyer judges are awarding or approving lawyer fees, directly and indirectly, amounting to billions of dollars, all in violation of conflict of interest laws. As long as there are lawyers, there will never be any law, constitution, or justice. There will only be mob rule by a mob of lawyers. Case law is unconstitutional as case law is enacted by the judicial branch of government. When a lawyer judge instructs, directs, or gives orders to a jury, the lawyer judge is tampering with the jury. He also tampers with testimony when he orders the answers to be either yes or no. The lawyer judge also tampers, fixes, and rigs the trial when he orders anything stricken from the record, or when he rules certain evidence and the truth to be inadmissible. This makes the trial and transcript fixed and rigged because the jury does not hear the real truth and all the facts. Juries are made into puppets by the lawyers and lawyer judges. All lawyers are automatically in the judicial branch of government, as they have the unconstitutional title of nobility, Article 1, Section 9 and 10, as officers of the court. Citizens have to be elected or hired to be in any branch of government, but non-lawyer citizens are limited to only 2 of the 3 branches of government. Lawyers, as first-class citizens, can be hired or elected to any of the 3 branches of government. Lawyers, as officers of the court in the judicial branch, are unconstitutionally in 2 branches of government at the same time whenever they are hired or elected to the executive or legislative branches. This is a violation of the separation of powers, checks and balances, and the conflict of interest laws. District attorneys and state attorneys have taken over the grand juries from the people, where the people are denied access to the grand juries when they attempt to present evidence of crimes committed in the courtrooms by the lawyers and lawyer judges. The United States Constitution, being the supreme fundamental law, is not and cannot be ambiguous as to be interpreted, or it would be a worthless piece of paper and we would have millions of interpretations, unconstitutional amendments, instead of the few we have now. That is why all judges and public servants are sworn to support the United States Constitution, not interpret it. Under international orders, all lawyers, whether they left law school yesterday or 50 years ago, are exactly the same. All lawyers have to file the same motions and follow the same procedures in using the same unconstitutional lawyer system. In probate, the lawyers place themselves in everyone's will and estate. When there are minor children as heirs, the lawyer judges appoint a lawyer, a child molesting Fagin, for each child, and at times the lawyer fees exceed the total amount of the estate. An outrageous amount of tax money is directly and indirectly stolen by lawyers. Money that is budgeted to county, city, borough boards, school boards, and other local and federal agencies eventually finds its way into the pockets of lawyers, as all of these agencies are tricked and forced into eternal extortionistic litigation.